Court will now hear oral argument in Dostart versus Columbia Insurance Group. Counsel ready to proceed? Yeah. Mr. Mallory? Or no, Mr. Carmoney.
May it please the court, counsel. This case represents a really pretty straightforward coverage question, and it involves a commercial general liability insurance policy that my client, Columbia Insurance, issued to a contractor called Tyler Homes or Tyler Custom Homes. The question here in this case really is, does that commercial general liability insurance policy provide some sort of liability coverage for fraudulent practices that were committed by its insured or its principals? We're here on further review. The Court of Appeals, in its opinion, wrote, resolving the coverage dispute requires deciding the factual issues of what conduct the insured defendants engaged in that led to liability in the unsatisfied judgment. And while that may be true, in this instance, the jury in the underlying trial did exactly that. It resolved all of those factual issues. I was invited a number of times by members of the panel of the Court of Appeals to go into aspects of the record, the factual record in the case, and I persistently, maybe to their frustration, I insisted on reminding them that they had everything that they needed to know within the jury instructions and the verdict form from that underlying trial. And you'll recall from your review of the case that the 3 counts of liability that were charged against Tyler Homes by the Dostarts were contract, warranty, and fraud, consumer fraud. Those were the 3 things. None of those 3 things are insured under a CGL policy.
Go through it in my mind because I think I know something about CGL. Am I correct? These facts I think were established. I mean, you did, you know, the deck action is based on a very limited record, but as I understand it, it's undisputed. Insured contracted to build a home for somebody. That's correct, right? The insured allegedly did not finish the home, and the home ended up having defects, right? Yep. And then the buyer sued the insurer and recovered damages, A, for the cost of completing the home, and B, for costs associated with not being able to move into the home on time. Is that essentially right? It seems to me we have to decide, one way to resolve is to decide whether that's an occurrence under a CGL policy. Case law tends me to indicate it's not, but I'm going to want to hear from Mr. Mallory on that. Is that a way to analyze the problem?
I mean, occurrence is going to be one of the 2 big issues that need to be considered here, whether or not it's an occurrence. And of course, you know, when you're looking at an insurance coverage question, you have to look at, I think in this case, 2 phases. There's the question about whether or not the claim fell within the insuring agreement, within the contract itself, within the policy. And then secondly, did the circumstances of the claim fit any of the exclusionary language? And those are evaluated in 2 different phases by courts. In one instance, in the first, that whether or not a claim fits the insuring agreement, that the burden of proof falls upon the plaintiff to prove. When there's exclusionary language, that it switches over to the insurance company to have to prove any exclusions. So the insuring agreement in this case is we will pay sums that the insured becomes legally obligated to pay because of bodily injury or property damage that is caused by an occurrence. So we know it's not bodily injury. That's the one thing we've been able to agree on. Property damage, whether this could constitute property damage, is another question that has to be evaluated.
Well, maybe you frustrated the Court of Appeals because you're kind of frustrating me. You're making this complicated. Occurrence is an occurrence just sort of an accident. It's not bad workmanship by the insured party here, is it?
I think I've gotten caught up in all of this, and it is really pretty simple, and I think maybe you're boiling it down exactly like it should be boiled down. An occurrence cannot be, or excuse me, an occurrence, which is an accident, is not something that is done, it's not something that can happen in the way that this case has happened. An occurrence is a sudden, unexpected event. That's the way the courts have consistently understood the word accident. The policy actually defines occurrence as an accident. So we don't have an accident here. We don't have a sudden, unexpected event here. This is a financial matter. It's not property damage. It's not physical injury to tangible property. This is economic damage that was caused by fraudulent conduct on the part of Tyler Homes or its people. I'm probably complicating it again.
I understand the Court of Appeals opinion, right? They say this could be an accident because you could have consumer fraud based on negligence. I mean, I think there are some problems with that, but where do you think they went wrong in that analysis?
What they went wrong in the analysis is that the only reason we even use the word accident in any of this discussion is that the Columbia policy and pretty much every other CGL out there is going to use the word accident to define occurrence. And so because that word accident gets in there, now we start talking about could conduct be accidental. That seems to be kind of where my opponent is going. Somehow or other, this could have been accidental or negligent conduct, and that somehow makes it fall under the policy. Well, that's not really true. The only reason that it would fall under the policy is that if there is an occurrence that can be established and proven. So accidental conduct, maybe to expand a little bit further, accidental conduct is not the same thing as expected or intentional conduct. They can't be the same thing. I think the Iowa Court of Appeals felt that there was still a remaining fact issue on that, but we believe it's very clear based on the way the instructions read, where the only way you really get to that finding of liability on the fraud count is to find that there was a deception, a false pretense, false promise, misrepresentation, all of those things that are listed in that instruction. And then, beyond that, not only did the jury find that there was they determined yes on the question of was there an intentional fraud committed. They went on to award punitive damages for willful and wanton disregard.
Not returned, had returned a verdict on the consumer fraud, but not on the punitive damages, and said it was not willful and wanton. Would that change your argument?
So, Your Honor, I would be saying exactly the same thing. You could still review the instructions and the verdict form and get to where you need to get. That's just icing on the cake for us. That just establishes once and for all that this was not some sort of accidental or negligent conduct on the part of the builder.
Sorry, go ahead. If you got a follow-up, go ahead.
The Court of Appeals seemed to be distinguish this case from the Yegi case, or however you say that. Can you address that?
Yeah, I never understood that. I thought the Yegi case was exactly 100% on point with this situation.
The statutory consumer fraud was a lesser mens rea than the common law fraud.
I think they did. I think that's been part of, really, I think that's been the fundamental argument that the Dostarts have made from the beginning. That's really been the fundamental point that they've made, is that when the Yegi case was decided, that it didn't involve the statutory consumer fraud provision under Chapter 714H. But if you look at the way the instructions read, the jury didn't know whether they were finding consumer fraud or common law fraud. All they know is that they had instructions, and the instructions made it so clear that the contractor acted with intent. And then there's the discussion about, well, intent to deceive or intent to rely. That seems to be kind of one of the fundamental questions that's come up. Well, I don't understand the difference in that, in this instance, the way the statute is written, if it's the intent to rely, it's the intent to rely on the deception. So to me, they're the same. I've tried to understand it more than that, but I don't. There's another reason I think that, something else that the court should consider, and that is just the fundamental idea that what are we doing if we open the door to an insurance carrier's commercial general liability policy covering intentional fraud on the part of an insured? Does that mean that somebody can decide that they're going to go out there and commit fraud against another party, and they say, well, it's okay because I can just go get an insurance policy that's going to cover that, and it won't ever cost me anything? Clearly, that's something that we don't want to have.
Or wouldn't that dilute the purpose of punitive damages to deter wrongful intentional conduct if your liability insurer would reimburse you for that?
Good.
Wouldn't it?
Bad precedent, and that's exactly what one of the concerns that I would have. It would change, I mean, we would have a different law if the Court of Appeals opinion is allowed to stand in this case. Things would be different in this state. Insurance carriers would have to completely rewrite their language in order to try to comply with a new standard. It's been a fundamental understanding of courts throughout, over many decades that intentional fraudulent conduct is not covered under an insurance policy like this.
Have clear precedent on whether punitive damages are insurable.
In many instances, and I say that only because I know that some of my insurance clients do provide coverage for punitive damages. And for example, in a drunk driving case or something like that, auto policies do provide coverage for that. If the insurance company wants it to, and if they write that into the contract.
On insurance law and coverage and premiums in Iowa, if we broaden the definition of occurrence to include construction defects.
Dramatically change the entire underwriting scheme. It would dramatically change the actuarial analysis of what insurance companies would be required to cover. It would dramatically increase premiums across the board for the policyholders that are attempting to obtain these policies. And of course, commercial general liability policies are very, very common policies. It's one of the very common ones.
Win on either no occurrence or the intentional act exclusion. Is there a reason we should address both or one versus the other?
That there is a different burden of proof. I don't know that necessarily applies so much here. We're not, we're not talking to a jury and all that. But they go hand in hand, but they are a little bit different. I think an occurrence is the question, or excuse me, you asked about the intentional act and an occurrence. Well, occurrence implies an accident. An accident can't be intentional. They can't be the same. Intentional act, when the burden shifts over to the carrier to have to prove that, the intentional act exclusion in this case is we do not pay for loss which results from an act committed by or at the direction of an insured with the intent to cause a loss. And our position is that the instructions that were considered by this jury and used to fill out that verdict form make it very clear that they believed that there was a specific intent to cause the loss, that's incorporated in that language. So I guess for purposes of considering them, they're very, very similar in terms of how they apply, but it gives the insurance carrier two different points of analysis, which someone who is seeking benefits would have to get through all of those. So yeah, we would have the property damage question, we'd have the occurrence question, we'd have the intentional acts question, and if we're successful on any of those three, then the decision of the Court of Appeals should be remanded back. I think that concludes my argument for now. Thank you very much.
Thank you. May it please the court. Counsel. This court has consistently held that the purpose of liability insurance is to provide coverage, not defeat it. Yet today, Columbia comes before this court and asking you to decide exactly that, to defeat coverage, not because of what the policy says, but because of what the policy does not say. Columbia asked this court not only to supply an exclusion that is not in the contract that it wrote, and it chose not to include in that policy. Columbia also is asking this court to ignore the terms in that contract.
Ask you to focus on occurrence, like I said I would. Under your view of occurrence, if I operate a retail store and I sold a piece of merchandise to somebody and it didn't work, there was a defect in it, that would be an occurrence, right?
We are applying, I don't quite understand the facts as Your Honor has set them out. The definition of occurrence is set forth in this policy, and this court should enforce the policy as written under and as interpreted under Iowa law. If we look at the Boer case, this is where this court, this is 944 Northwest 2nd, this court just a few years ago determined that gross negligence may be an occurrence. In that case, the court held that gross negligence, that an insurance policy, a GCL policy, does not automatically exclude coverage for gross negligence, for reckless conduct. And
I agree with that point, but I agree with that gross negligence could be an occurrence, but it still has to be what one would commonly view as an accident, not just defective work or defective product where the only problem is the defect to itself. It doesn't hurt something else. So another example would be like a car dealer sells a car and it turns out there's a problem with the car, which often happens. I mean, would that be an occurrence that you could go to the car dealer and sue, and the CGL insurer would have to provide a defense and ultimately insure it, right? Under your view?
hypothetical based on those facts, it could possibly be an occurrence, and that is exactly why the Court of Appeals and the District Court got it correct. Based upon the record that we have as we sit here today, there are not enough facts to determine whether or not the provisions of the policy exclude coverage. What we have here is a situation where Columbia is coming before this court because their summary judgment was denied, where both lower courts have said that there are fact issues that preclude the entry of summary judgment, and without submitting any factual evidence.
Could a claim for merely negligent conduct satisfy a claim under the Consumer Fraud Act?
The Consumer Fraud Act provides that coverage for acts and omissions, generally, wherein the statement is made with an intent to rely, but there is no intent to harm. There's no scienter in this court.
Doesn't the perpetrator under the act either have to know or reasonably should know that what they're doing is fraudulent?
Or
that are set forth there. But it's either know or reasonably should know. I don't see negligence satisfying that, does it?
as I read the consumer fraud statutes, and we're under one of the multiple definitions, if they commit an act that they know or reasonably should know would be a material omission, then it is an event that could constitute consumer fraud if it meets all the other elements. And if we look at the standards of negligence and we look at the conduct, I believe that the statute, and I believe that the case law that has interpreted Iowa consumer fraud law would establish that there is no heightened burden. When we're looking at the mens rea for consumer fraud, we do not have to have gross negligence. We do not have to have recklessness nor intention.
Now, let's go back to the occurrence language. Why is negligence relevant in making that determination? I mean, we have to have evidence that there was an accident, right? And an accident may or may not be caused by negligence, or may or may not occur in the absence of negligence. So what is the accident in this case?
In this case, what we look at is we look at the jury instructions as was submitted, and that was the law of that case. That case was not appealed. And when we look at the jury instructions in the lower case, there were acts and omissions related to the advertising and the sale of the construction of this.
It's still, I mean, I see all these cases that say defective workmanship is not an occurrence. And then I do look at the verdict form, which is part of the record, and what you recovered was cost of completing the home and costs associated with not being, or what, you know, what not what you recovered, but what was recovered was costs of completing the home and costs associated with not being able to move into the home. So that strikes me as, you know, not something that's, that strikes me as faulty workmanship, right?
We're having this debate because this is exactly why the lower courts got it correct. And that is because when you look at the verdict form, when you look at the decision of the lower court, we have questions of fact related to what is or is not included in those damages. We have questions as to what it...
That verdict form seems pretty clear as to what the damages were awarded for. So what's the question that we would need to know?
I agree that the verdict form is very straightforward. When we look at the definition of property damage under the policy, it includes the physical as well as the loss of use, something that has been overlooked by Columbia. We do have loss of use as a specific covered event under the policy. And
I mean, and you did recover. I forgot there was an assignment, but it's still, yeah, it's still cost of completing the home and loss of use. It isn't. This isn't a situation where like the home fell down and hurt somebody, or the home fell down and damaged something else. This is simply the cost of finishing it, and loss of occupancy. That's just faulty workmanship, isn't it?
this is not simply a faulty workmanship case. If we look at the cases that have held that there can be coverage when we're looking at a faulty workmanship, there's a distinction between whether or not the faulty workmanship was done as a result of a subcontractor or whether it was done as a result of the insured. When we look at defective workmanship cases, we look at, for example, a roof. If the faulty workmanship was on the roof and the water leaked through the roof, causing damage to the sheathing, causing damage to the drywall, it is a covered event under a GCL policy. So the fact that you simply have defective work involved in construction does not give you the information that you need to determine whether or not you have coverage or you do not have coverage.
It's still cost of finishing the home, which was the entire responsibility of the contractor here. So there's no damage to anybody else's property. It strikes me as the key distinction, right?
The discussion seeks to merge the definition of occurrence with property damage. If we have an occurrence, and we believe that we have an occurrence, it was an unintended event, there is no intentional conduct, and when we look at the definition of intentional conduct under the terms of the GCL policy, you have to have both an intent to harm as well as an intent to act.
What does the fact that the verdict also included the willful and wanton?
This court has routinely held, whether it be the Jungling case, the Thompson case, the Baldwin case, this court has consistently held that insurance coverage may exist even when conduct is reckless, willful, and wanton, so long as the insured did not subjectively intend to cause the injury.
Example, in a car wreck case, you might have, right, willful or wanton situation. But in this situation, you've got a jury instruction in the marshaling instruction that element 2, defendant acted with the intent that the Dostarts rely on the practice or act. Help me reconcile that with the idea of an accident, which would be something that would be unexpected from the perspective of your client.
The statement is made with the intent to rely. Here, the accident is with regards to the misrepresentations or the omissions of the information that is being conveyed. And when we look at the cases that have interpreted consumer fraud, we see that the fact that you can have an erroneous statement that is made with the intent to rely, that does not necessitate that you had an intent to harm someone, nor
You to the instruction for the exemplary damages, which does say that the defendant's prohibited act constitutes willful and wanton disregard for the rights or safety of another. So why doesn't that fill that gap?
wanton conduct. Reckless conduct does not equal intentional conduct. And this court has held that across the board. I've cited these cases for your honor. So the mere fact that
Best case for saying willful and wanton is not intentional for purposes of an insurance contract.
Thompson, Baldwin, those are all cases that have held that fact. And really it's a dangerous precedent to say that reckless conduct is intentional conduct and excluded. For example, like
May's point real quick, or question about element number 2 in the marshaling instruction. So the policy covers accidents, but this jury found that the defendant acted with intent. So how can that be an accident? I guess I'm struggling with your answer. Could you explain that?
the definition of what constitutes an accident under law, we look at whether or not the incident was in fact the intended to occur or not. And what we've got here is there's only an intent to rely. What the misrepresentation and the omissions that were conveyed, we did not say that they were intentional. You can have accidental misrepresentations, but an accidental misrepresentation, and that is the occurrence that we're looking at here, is whether or not there were misrepresentations and omissions of fact. And when you make those accidental, unintended misrepresentations, it still can constitute consumer fraud.
And back to instruction 29, conduct is willful and wanton when a person intentionally does an act of an unreasonable character. Didn't the jury find that here? That this was intentional?
The jury found that some of the actions, there's nothing that I read in those jury instructions that say that all actions, again, a reason why trial is necessary, but the jury did find that some actions constituted willful and wanton conduct and reckless conduct. But simply because you have willful and wanton conduct and reckless conduct does not equal a bar of coverage. We have, in an OWI instance, we have an individual who drinks too much, goes out and drives, reckless conduct.
Is unintended. They didn't mean to get in an accident. How is a failure to complete work on building a home an accident?
The failure to complete work in this case, we have work that was completed that was not done appropriately. We have work that was completed that caused damage to other areas of the house. Again,
that were part of the same work. I mean, other areas that the contractor was doing. I mean, it's still internally defective work. It didn't hurt something else, right?
it's never held that simply as a matter of law, because something damage caused to a house equals no coverage. We have the cases wherein subcontractors' defective work has,
Somebody else's property, not their, not, you have your clients had a contract with the contractor to build a house. The contractor, through their negligence, incompetence, whatever, didn't build it appropriately, and there were problems with it, including it sort of self-harm. But that's still not, I think the general case law says that's not an occurrence. It's still faulty workmanship, right?
okay. In this instance, the work that we're talking about, and by the way, there was no breach of contract. The jury found that there was no breach of warranty. That's where those defective workmanship cases come into play. And in this instance, we have subcontractors that committed defective work. And so when we look at the case law related to defective work, their contract claims, they are contract-based, not consumer fraud-based. And so we look at the actual incident. The occurrence relates to the misrepresentation and the omission. And we believe that the underlying verdict, because it stems from consumer fraud, not common law fraud, it does not require deceit or intent, and it is the insurer's burden to prove that these exclusions apply. The fact is that as both lower courts have held, there is not enough evidence to determine what is encapsulated in each one of those damage calculations to determine whether or not it's recoverable or not. There's not enough evidence to, before this court to determine what acts and omissions are we talking about. Are they intentional? Are they not? Are they reckless? Are they not? Based on the record before this court, both of the lower courts got it right. And we would respectfully request that this court affirm, allow this case to go to trial, so every issue that your honors have raised and the questions that need to be answered so that they can be answered appropriately through the due process procedures. Thank you all.
So everything that we need to know the answer to the question is contained in the record. The record that we submitted, our appendix, is really very simple and straightforward. It incorporated the policy itself. It incorporated the jury instructions and the verdict form. That's really it. Those are the key things that we need to know. We've been talking about the word accident and accidental today, and this court has defined that word in the past in the context of insurance interpretation. In the Purcell Construction versus Hawkeye Security case from 1999, this court defined accident as undesigned, sudden, and unexpected event, usually of an afflictive or unfortunate character and often accompanied by force. I think that's a way of describing in more detail what we all know an accident to mean, and it doesn't mean with this case. Accident?
It could be, but hypothetically, if we disagreed with your argument and affirmed, what would you instruct the jury to be to decide to answer these coverage questions? What would that look like?
Juries are supposed to answer insurance coverage questions. I think those are matters for the court, and that's why we took this immediately up on summary judgment when this lawsuit was filed. It's why we've continued to appeal it when we felt that lower courts got it wrong. There is, I think, these are innocent people. I mean, the plaintiffs in this case did not do anything wrong. They're victims of these contractors, but there is a remedy available to them in the original case that they brought and won. I mean, they have the opportunity to go after and pursue and execute against the defendants in that case. That's what they should be doing instead of advancing this lawsuit against the perpetrator's insurance carrier when there's clearly no coverage in place.
Affirm and send it back. Could you put together a more robust record about what happened below to support another summary judgment motion?
That's really what Judge Langholz asked me about at the argument downstairs. And in his opinion that he drafted on behalf of the panel of the Court of Appeals, he indicated that maybe there's more that we could put together that would still allow us the opportunity to seek summary judgment on the legal questions, but with a more robust or more bolstered record in place. I don't know what in the world we could add. And I felt at the time when we had that back and forth down on the third floor, I felt like, you know, that sounds like we're dragging ourselves into fact issues. I mean, we were there on summary judgment, and we were there on an appeal that resulted from what we believe is an erroneous failure of the court to provide summary judgment.
Counsel's insistence that willful and wanton can be is less than intentional.
I don't understand it. I don't understand the argument. I don't even think we need to get to willful and wanton. We talked about this earlier.
Between the intent to rely and the intent to harm, I think that was the distinction he was trying to make.
That's been part of their fundamental argument from the beginning here, and the intent to deceive versus the intent to rely seems to be a big part of what they're referring to as the difference between consumer.
The statute is by an omission of fact, and so if they omitted facts that they should have given, so maybe that's not quite deception. Is there a distinction between some of those terms?
There are. I mean, that's to some extent, they include a list of those different things: deception, fraud, false pretense, blah, blah.
The mens rea maybe with respect to is omitting something a lesser mens rea maybe than deception.
But we also have that second element or that second instruction that in the marshalling instruction there that says the defendant acted with the intent that they rely upon it. I mean, between that and if we add on that icing on the cake I mentioned earlier, the willful and wanton on the punitives, I mean, it's crystal clear that this was intentional, wrongful conduct that is not of the nature that would be covered under liability insurance. Thank you very much.
We'll adjourn for the morning.